join.
Yeah, I just hey Ferd, thanks for doing this, by the way. I'm like shopping in the sort of Pennsylvania surrounding areas. What states is your firm able to help out with, like contracts, PPMs, leases, and stuff like that?
Yeah, good question. So yeah, thanks for having me, Michael. Just kind of quick intro comment, if you will. So any of the comments that I give would be general advice. I'm not your lawyer. I'm not giving you legal advice. I can't answer specific questions on something which is an adversary. So like if you have a question about how should I value this property, or how should I pursue DD, I can answer that. But if you say something like, "Hey, I'm under contract to buy this property from John Smith in Cleveland, Ohio," I may not be able to answer your question because I might represent John Smith. So be generic in your request, and then I can um, answer more thoroughly. But to your immediate question, so our firm, we have 5 lawyers here. We handle mostly real estate transactional work, contracts, leases, title survey, zoning, due diligence, syndications, PPMs, corporate stuff. We can do bank docs, either seller finance, drafting them, or we can do like CMBS, Fannie Mae, HUD loans, that kind of stuff. So as far as which states we practice in, we've done deals in 45 states. There's certain states we're not legally allowed to do certain scopes. So for example, in the Carolinas, I cannot do your closing. You need to get a closing attorney. So we could do your rest of your transaction. We would just hire a local guy to handle the closing. If you were doing Iowa, we are not allowed by law to do Iowa title insurance because it's a reverse process. We're actually, in that case, we're also not skilled to do Iowa title guarantee. So we would hire our local counsel for that. For most of the transactions, I mean, it's like 95% of the transactions, we can do the full soup to nuts. So the states you mentioned, Northeast, we've done deals in those states. I haven't done California, don't want to, haven't done Alaska, haven't had a chance. And then Florida, we can do transactional work, but there's certain additional things around what's called a prospectus, which is like a supplement to your lease. It's different than a prospectus, like in an offering memorandum, but that requires somebody to be local. And then generally litigation, there's a guy named Scott here who does litigation, but that we pretty much need to have a second attorney involved to enter into a court or tribunal. But on real estate transactional work, we pretty much could do it wherever. Same with leases. I've got 30 states completed right now, or 31 maybe, for state specific mobile home park lease packets, contract, site lease, home lease, park rules, state specific memorandum, and then any one-off documents that the state requires. So those we've just been doing, as we get in order, because I haven't done Alaska. It's probably last on the list, but we've done most of the Midwest, upper North, Southeast, and then I've got about half of the Northeast completed on the lease packets.
Well, thanks.
You got it.
I got more if I'm not.
Let him rip. I see.
Yeah,
I
let
see
him rip,
D's
Eric.
on here. I see D's on here. Hello to D. Yeah.
So Ferd I live in New Jersey, and the General Assembly just passed a rent control bill in New Jersey of 3%, just on mobile home parks. Well, it's still pending in the Senate, but being as blue as we are, I mean, it crushed it in the Assembly. It wasn't even close. What is your feeling on sort of the legality? Sorry if I'm huffing and puffing. I'm out on a run right now. What is the legality, in your opinion, of a specific rent control law that targets mobile home park owners like that?
Well, I mean, I'm not familiar with New Jersey law in that specific case, but in general, in constitutional law, and this would be a constitutional law matters, and I'm not a constitutional law scholar, but I do a lot of zoning work, which is somewhat related. And generally, there's different levels of scrutiny that you have to pass for a law to be valid. So, for example, if we passed a law saying no white people can go to this city, well, that's a racial related question. Well, in order to have a law like that, it has to be a really high level of scrutiny in order to survive. That law would probably not survive. It would not hold up. Now, if it was no women involved, okay, that's another really high level scrutiny. But there are some organizations, like I'm a Catholic, I'm in the Knights of Columbus. Well, it's for men only. There's a women's derivative of it also, but the Knights of Columbus are for men. It's not necessarily discriminating against women, but it kind of is. It's not meant to, but it's men only. So it's been approved. So there's a lower level of scrutiny than say race. For the rent control, Typically a city law only has to have what's called a rational basis. Like it'd have some rational basis in order to be upheld. So I would imagine the proponents of that law would say mobile home park tenants need rent control protections more so than single family or apartment renters because if the apartment doubles the rent overnight, Eric can load his crap into a van and drive down to the next apartment. But in the mobile home park, if the rents double overnight or 10x over 10x overnight, well, it's really cost prohibitive for Eric to move his mobile home to a different park. So Eric needs additional protections and needs rent control. So there's a rational basis, and that's going to be that laws be upheld. Now, personally, I wouldn't hope to see that result. I own parks in Illinois, and there's currently some legislation that's similar in the House. It hasn't been even been introduced, it hasn't been formally debated yet. But I think there's, rent control in general is bad news and bad news for everybody, but in particular in the short run for landlords. And is rent control going to continue to grow? I think it will. I think it's somewhat tempering down a little bit because, housing prices at some point are going to peter out. And we see apartment guys, a lot of apartment guys are struggling right now. So, occupancy's down, NOI is down. So in order to get the occupancy back up, I think that, I've seen it in lots of markets where some markets is down like 9%, rental rates on apartments. So I think as rental rates and apartments go down, I think the fervor over rent control in general will start to dampen. But to your immediate question is that law in Jersey going to be upheld? Uh, I would say probably. I don't know how it's written, and the guys and gals that write laws are pretty nuanced and pretty good at it, and and if they're smart, they write them in a manner that there's not very much in the way of exceptions.
Yeah.
So
Yeah, that's fine. I figured. I just thought I'd ask.
yeah,
Um,
it would probably make me, if you were looking at a deal in that state, it would probably give me pause. Now, also, the devil's in the details. There's some states that have rent control, like Oregon, for example, it maybe says like you can go 7% plus CPI. Okay, well then you're talking 7 to 12% rental rates. That might be more than you were going to do anyway.
yeah.
So that's not that onerous. Other times they'll pass a law and they'll say, it's like I got some parks in Iowa, and Iowa had rent control on the docket a couple years ago, and my recollection was it said something like, today's March 20th. If rent control is approved today, starting January 1, you only be able to raise rent 3%. So then here's what I was going to do. Let's say I was planning on raising rent $10 a year for 10 years. It's $100. I was going to send out a notice saying rent is up $100 now, but because that's a big increase, I'm going to give you guys rent rebates if you pay on time, and you get a $90 rebate this year, an $80 rebate the next year, or $70 the next year. Because I don't want to, and tens and $10 a year is probably a small example, but let's say I was going to do 30 a year. Well, that's 300. I can't raise the rent right now, 300, or nobody's going to pay it. I'm going to have a bigger problem. But I was going to think maybe I'll just say it's 300 and do a rebate because I got time. Now, others may, depending on how the law is written, it could come out and say, um, today's March 20th, rent control is in effect starting now. And then you're really stuck. So it would behoove you to follow that legislation. If you're involved in your state MHA, they'll probably do it for you too.
Yeah, that's actually interesting because I did think about that. Raise the raise of rent and then the rent credits. And I actually heard another outfit that did that. I think it was in Washington or something. But yeah, that's interesting.
Yeah, the problem with that theory, that's again, I was considering doing it in Iowa. It never became ripe. But the problem, so to speak, with that theory is you're now testing the boundaries of the legislature's intent, and that could be a bad position to be in.
Yeah.
So I would probably not be the first guy to do that because you don't want to be the guy that's getting the investigations, the test case, and all that kind of stuff.
Thanks. Then last question I had for the time being, at least, is like, what are your must-haves in a zoning letter?
So there's a must-have, and then there's the want to. So we've done zoning letters in like 150 cities. So Hunter is my main associate on zoning. So here's how Hunter and I talk about him. He does most of the research, and then he sends me a recommendation where he gets a letter, and he says, "Look, we got a letter back and it's an A letter, A minus, B, C, D, F, etc. So I kind of think about it like this, a B letter is good enough and you should proceed. An F letter, you should not proceed unless you're ready to fight a litigation matter. Here's what the A plus letter looks like. The A plus letter says, let's say there's 100 spaces and there's 20 vacant. The A plus letter says, I am John Smith and I am the authorized person to speak on behalf of the city. I am the city manager, city attorney, planning coordinator, whatever. And I'm on, and like my signature's at the bottom, the city letterhead's at the top, and I say, I here represent and warrant for you, for your successors, your heirs, your assignees, that the following is true. The park is either A, legal conforming, or B, legal non-conforming, and that the park I can bring in homes of any age, of any size, and put them on all 20 of the vacant lots and all 80 of the currently occupied lots if a home is removed. And I can do it with 0 setbacks on the property lines. Practically, you're not going to have 0 setbacks between homes because the fire code will trump your grandfathered rights. So it says I got no setbacks, and then I'll say there's no permit fees, and there's no tap fees or development fees or transfer fees. And to be clear, the regular maintenance of the park, including road repair and demolition, removal, and infill of homes, will not constitute, quote, development, because that would trigger development provisions of the code like a new park, but instead is classified as, quote, pure maintenance. Lastly, the term mobile home shall include RV, camper, mobile home, and manufactured home. That would be the A plus letter. And you can do whatever you want, and you got it in writing on letterhead, etc. If you get a B letter or better, you can typically get a zoning endorsement on your title commitment, which depending on the state, it's either $0 up to like $500, and then it's like an additional layer of insurance or protection in the case the current bureaucrat changes his mind or retires and the next bureaucrat differs. So what's the good enough or the required? Typically, you want to be, it depends on the plan, the project. So if the park is 99 out of 100 occupied, I'd say, hey, Eric, does infill of that last lot really matter? Like, is it required for your business plan to make sense, or is it gravy? And if you say it's gravy, I'm at 99 out of 100, then I'm going to say, okay, well, here's the deal. This particular city says, I got a city like that, Des Moines, Iowa. I got 3 vacant spaces. I think there's actually a case law in Iowa. I think I could win a case to bring in a home. But Iowa takes the position that I'm not allowed to fill my vacant 3 spaces. If it was 30 vacant, I'd be fighting like hell because that's a big number. It's 50. That's 50,000 a space or more in that park. So that it'd be 1.5 million. Now, in theory, still it's 150,000 for me, but I haven't fought it yet. One, because I got some other projects I'm working on that are more priority. But 2, it's only 3 lots. And if I fight City Hall, I'm going to have, I'm a lawyer, but if you're not, you're going to have, fun suing them. You're going to have 50,000 in legal fees in a minute. And if it goes to appeal, you're going to be 100,000. And if it's got a complicated fact pattern and it goes to federal or state court, you could be 150, 200,000. So for me, maybe I'm a lawyer, but it's still my time. If I spend 150,000 of my time, I'm not doing it on something else. I'm not billing the next client. So I'm billing myself. So the other problem is if I fight City Hall, is there anything else in my park that I have exposure to? Do I have electric pedestals that are outdated? Do I have homes that have tires in the yard? Do I have a home that's encroaching over the property line? Well, if so, I may not want to fight it. So here's what most people do on zoning, and this is what I consider a door number 2 type of zoning letter. Like, what do you get behind door number 2? I don't know. Let's open it. And here's what door number 2 looks like: is you just get a zoning verification letter. And that's what a lot of the other, I'm a guru, I guess, but that's a lot of the gurus in the space will tell you is just get a zoning verification letter. Well, here's a zoning verification letter says. It says, Dear Eric, your park address is 123 Main Street. The parcel number is X. Parcel X is zoned R2. Okay, great. It's verified. That's worthless to me. What is R2? Well, you can look at the code. Does R2 say you got 30-foot setbacks on front and back? You only got 80-foot lots and you want to put a home on there? 80 minus 30 minus 30 equals too small, and now you can't infill. So what we typically want to do is fight for with most parks, there's like 1 to 5% of parks that are illegal, meaning they were illegally built or permitted at the time they started. You got like 1 to 5% of parks that are legal conforming, meaning they were legally constructed and they're in conformity with current codes. That really only happens on new development or parks that were really spaciously designed, or cities don't have real zoning code. The 90% or plus parks in the middle are what's called legal non-conforming or grandfathered. And what that typically is, the park predates the modern form of the code. So what we typically want to do in that is, and this is where you go for the B letter or better. You say, look, it's 100 spaces. Okay, the city says I can't infill because R2 says I need 30-foot setbacks on front and back. Well, it only gives me 20 feet of earth, which means practically I can't put a home there. So where you push back is you go to the city, you look at the current code, you look at the prior code, and you negotiate with them and you argue with them and you tell them, look, I predate the code. This park's been here since 1960. Your code's 2009. So I was legal in 1960. I'm non-conforming today, so I have grandfathered rights, legal non-conforming. Therefore, I'm allowed to continue to operate the way I was in 1960 with limited exceptions. The only things that can trump your grandfathered rights are abandonment, nuisance, and public health, safety, welfare, which is basically fire code. Well, nuisance is like you're a super slumlord and they've gone through a statutory lawsuit. Abandonment is what the city says, well, the lot's been vacant for a month, a year, 10 years. You therefore have abandoned it. And that's what most cities say. So so that starts off as an F letter where they say you can't bring homes in those vacant lots. Where we try to get it to a B is which is, getting good enough. We try to get the city to sign off in writing that we are allowed to bring in homes of a certain type and size. And the logic is essentially, think about a hotel room. Holiday Inn, it's got 100 rooms. The one by the ice machine is vacant most of the year. It's, the whole place is full on New Year's Eve and Valentine's Day. And then for 10 months in a row, one of the rooms is vacant. That doesn't mean it ceases to be a hotel room. It just means the hotel operator was not at full occupancy. So we say, look, this is still a mobile home lot. They go, well, but the property's been abandoned. We say, no, the property hasn't been abandoned. The property owner has been unsuccessful at renting that parking space for some period of time, perhaps 10 years. And it's just a parking space. And if, Home Depot has parking spaces, there's 100 of them. Most of them are vacant, except for Black Friday. So the one on the very end by the street is vacant. Doesn't mean it stops being a parking space. Doesn't mean Home Depot abandoned the rights to have a car parked there. Now, within reason, maybe you can't put a semi truck there or a school bus because it's not big enough. But a reasonable sized vehicle, I drive an F-150. My dad drove an F-150. My grandpa drove an F-150. Well, guess what? My truck's the biggest because they're making trucks bigger than they did 40 years ago. Well, it's the same thing with manufactured homes. They're making them bigger. So you can't, some cities will say, well, you got to put a home of the same size on there. Well, that's like a C letter. Because great, if I can find a 12 by 48, I guess I can infill. You want to be able to get the rights to put any home there. So where you can cave is if I just did one the other day where the lots were 105 feet from street to property line, and the city said you had 30 and 20 on setbacks, which is 50 feet, right? Which you only got 55 feet. Well, that's really small. So here's what the compromise we were able to do. We told the city, look, these streets are private streets. We already got the home next door that's on the street. If the street is 30 feet wide, so there's plenty of room for ingress, egress, fire truck. So don't tell me the fire chief's going to be, all fired up on this, pun intended, I guess. And so here's what we did. We said, tell you what, if we will agree to give you 30 feet on the back, if you give us 0 on the front, which gives us 75 feet, which is not enough to put in a 76-foot home, but it's enough to put in a 72, which is good enough in most places. So that's like we turned it into an A- letter. Sometimes where you take the F letter and you turn it into a B or B- is you cave a little. And I got one client in particular bought a ton of parks, and we do a ton of zoning reform. And here's what we always do. He goes, look, I'm not going to bring in old trailers. So tell the city that we'll agree to bring in only homes with vinyl siding and shingle roofs, which practically means 1995 or newer. He's not committing to be brand new, because some cities want you to do brand new, or 5 years old. But realistically, he's like, look, I'm not going to bring in the 1980. And if I wanted to, whatever, I'll just bring in a 2000 model and still a used home. It's still cheaper. And then you can tell the city that I will agree. And then they can, because what they don't want to do is give you some grace And then the slumlord down the street uses that same grace on themselves because they can't discriminate on one owner versus the other. So what you do, you say, look, I know the other guy's a slumlord, so let's not make it about the age of the home. Let's make it about the quality of the design standards. So, what's the difference between a 2010 and a 2011? Nothing. The difference between a 1980 and a 2010 is the 1980 has a metal roof and metal siding. So say what you guys really don't want is old crappy metal trailers. So here's what we'll do. We'll agree to put in a design guideline that is going to require quality, and I'm willing to put in quality, but not brand new quality. I'm willing to put in like reasonable quality, like B level. The slumlord down the street, he's never going to go buy a 2000 model home. He wants to bring in a 1972 and drag it in with his F-250. So if that's the goal, is to avoid the guy down the street, let's just carve out, a better zoning letter. Sometimes you can get a conditional use permit. Sometimes you can get a variance. Sometimes you got to change the code. you know, the zoning letter for one park is the least path resistance. So like I said, we've done this in over 100 cities. Here's how it goes though. About a third of the time, the cities will sign whatever I put in front of them. Like they'll like return mail like within like 30 seconds. Those are easy. They sometimes sign stuff that's incorrect, but if it's favorable, we like let them make that mistake. About a third of the time, the cities will not sign anything. And or they'll just say, like, I live in Kansas City. If you bought a park in Kansas City, I can't get you a zoning letter. They got 100 lawyers in the law department in City Hall, and they'll say, fill out the online form, and we'll send you a zoning verification letter. 123 Main Street, R2. See the code online. And they'll say, I can see the code, I can read the code, I can interpret the code. That's that's not what I'm looking for. I'm looking for your interpretation. And if I agree with it, then great. I'm looking for your interpretation on letterhead with your signature at the bottom. So that's the soup to nuts on the zoning letters and zoning verification. It's arguably the most important portion of your due diligence. Now, obviously, you got to know the market, and you got to, there's that. It's I gotta, I used to do a presentation on the top 10 DD items. That's on the list. It's top 5 for sure.
So am I understanding correctly that you will send the language that you want the town to sign and ask them to put it on their letterhead and send it back? Is that what happens?
That's correct. But before we send the language, if I just send the language cold, they're going to say, get out of here. So we call them and I prove, just like I have in the last 10 minutes, that I know their job as well as they know their job, maybe better, but I do it in a respectable manner. And then I coach them into yes and yes and yes. And then I say, hey, this is a great discussion. You mind if I send you a letter? If you want to revise it, I'll send it in Word. If you want to revise it, by all means, but I just want to make sure we're on the same page. And then we send it. And then sometimes they just turn around and sign it because they just say, oh yeah, I'm at my desk right now. You got your stuff. Print, sign, return. Well, then we're good to go. Sometimes they won't ever. Sometimes they won't return call. You get the whole gamut. Typically, the bigger the city, the harder it is. Kansas City's a lot harder than small town Missouri. The West Coast has been harder than the Midwest and Southeast. And there's certain states like Tennessee or Texas or Florida that actually have state law that helps you, beef up your case. There are 4 or 5 states that have Supreme Court case law, like Iowa, Ohio, a couple others. But like we've done a lot of deals in like Colorado, Arizona, and we have a hard time getting them to sign our letter. They just say, fill out the online form. We'll give you a zoning verification form or zoning verification report, which, I don't, sometimes they try to charge you $500 too, which is like, if I'm just I can look at the map and see that it's R2. I don't really need if you're just gonna give me that letter, I'll save the $500.
What about towns with no zoning laws? What have you seen there?
That's the best. I'd still try to get it in writing from them, but the letter is real simple. It just says, "Dear Eric, I'm doing it right now. I'm under contract. I'm doing in Adams County, Illinois, and Adams County has no zoning code. So they just send me. I still get a letter, and they send me a letter that says, "Dear Ferd, there are no code of ordinances in Adams County. However, any state or federal laws that are relevant will apply." But those are easy.
Cool. Thanks, Ferd. Appreciate it.
You got it.
And I'll just interject here. I've had exactly those 2 ends of the spectrum that Ferd mentioned. Probably, Eric, the same park that you looked at in South Jersey. I know John Carlo looked at it as well. We've got a lot of East Coasters here, so some overlap. and they would not sign a letter. They didn't even know what it was, and they kind of punted me around between individuals within zoning and planning, and then like legal counsel for the town, and none of them would sign it. And so I punted on the deal because I was effectively advised against purchasing a park that where the zoning could be questioned after the fact. And then um, the exact opposite of that happened in the last park, which I'm actually in Elmira, New York right now. It's down the road. And I asked for it after speaking with zoning and planning and code enforcement for maybe 20 minutes because I was told by the seller that there was no way you could replace homes, that the zoning and planning board would not allow it. But I had that conversation with the zoning and planning board, and they said that's not true. And I immediately said, can you please rep to that? Sent the language, and they signed it and put it on letterhead in minutes. So it was the complete opposite of what I had experienced in South Jersey. So just interesting because echoing exactly what Ferd said, that was my experience. So yeah, just wanted to add that to the record there. And Ferd, I have a quick question before we jump in because
Can I
just
comment on that
close.
one? If it's
Yeah, absolutely. Go ahead.
if it's to
By
stay
all
on that
means.
same train for a moment. So here's what you can do though. If the city does not, if the city just says we don't do zoning verification letters or we don't do zoning letters, I wouldn't give up just on that. You're not going to get what you want, which is the gold piece of paper from them. But that's like I said, that happens like a third of the time. And I don't know when we start on this, where we're at on that. But what we do then is, that's our law firm. You can do it yourself. You can have your lawyer do it for those of you that have other experts that helping you with this. But when I have it happen, I say, dear client, the city is obstinate, will not sign a letter. However, here's a 20-page zoning report that we put together. Based on this and my experience, I think that you have legal conforming status or legal non-conforming status, and you should proceed or can proceed. Now, sometimes I'll say, there's an unknown. The city could say no, but if the city says no and you want to sue, you have a winnable case. And because it's violation of your property rights under the 1963 Civil Rights Act, if we fight and win, you get reimbursed your legal fees. Now, doesn't mean you should do that because it's not worth fighting over one lot, going in the whole 100 grand to see if I'm right. But a lot of times city won't give a letter, and doesn't mean you should walk away. It just means you need to feel comfortable with it. I mean, similarly, you do that every time you buy a park and you've never sold a house in that park. Like I'm looking at a park right now, I got 10 vacant lots. I don't know if the customers are going to show up. So what do? I do diligence. I do research. I do things like a test ad. I do things like look at market demographics. I look at the park. I look at competitor parks. I still don't know for sure if I'm going to ever be able to sell a home in that park. But based on, some tangential evidence, I can get to the point where I'm like, I have a high probability of being able to sell a home, so I'm going to take that risk. So if you don't get the signed letter, it could just because the bureaucrat is afraid to make a mistake. I had a guy in Hazelwood, Missouri, the city attorney. He said, we don't sign those letters. I said, why not? I go, I need because the code's online. And I said, I read the code online. Some of it is vague and ambiguous. I have my opinion of what it means. I would like your opinion so I know if I'm going to have a potential fight down the road. And he said, show me in the state law where I'm obligated to give you my opinion. I was like, good grief. He's just being difficult. Now, what he wasn't being was anti-mobile home park. He was just being anti-afraid to be wrong. So he just didn't want to give his opinion. But I did during the correspondence with him and discussion, I didn't get any vibe that he was going to be a problem. He was more like, look, if you're confident the code says you can do it, then just do it. But we're not going to go out there and like do an assessment of the park and verify the sizes and verify that the infrastructure is good and that there's no encroachments and code violations and all this other stuff. That's another thing I forgot to mention, Eric, to your question is that the A+ letter says there are no open code violations also, which the city should never sign in 30 seconds because they didn't even go look. But that's really just a way to, and I don't think I can really rely on that portion. I think it's kind of, an aggressive provision, but where it's helpful is every once in a while, the person you're talking to goes, oh man, not only can I not sign that, let me tell you about this place. We've been out there 25 times. Didn't the seller tell you? So that's kind of why I throw that in the template letter.
Eric, I saw you had a follow-up. Did you want to?
Well,
Did you
yeah,
want
my
to?
only other, thanks for that, Ferd, too. My only other follow-up is like in a town with no zoning, who should be signing that zoning letter? Because I'm dealing with I have a deal right now where I did send a zoning letter over to the township supervisor, who I had a 45-minute long conversation with about the zoning or lack thereof, and the town and how they look at this type of stuff. Just because it was so foreign to me that there would be no rules, because like I'm in New Jersey and you have to have a permit to sneeze here.
Yeah, so
And
it's
so I sent the letter over, but then his secretary signs it and sends it back to me. So it's like, what do I
well,
do?
if the secretary signs it, she's representing that she's he or she is the agent of the municipality. But typically it wouldn't be a member of the board of supervisors because they are typically not the action people. They're the, vision people. So generally I would say city manager. And if city manager wants, if there's no smaller towns that don't have zoning codes, they probably don't have a zoning department or zoning administrator. So you don't want the public works guy doing it. You want to go to the city manager and that, or city administrator, and that person, if they're not the right person, they'll give it to the right person.
Okay.
But typically, I mean, the city manager is the CEO of the town. Typically it's not the mayor. The city manager is, like in Kansas City, for example, the mayor is the mayor is now a full-time job. The city council is a part-time job, but city council makes like 40,000. The mayor makes like 80. The city manager makes 300,000. City manager is the executive running, a 2,000 person company. But that's the boss. Now, oftentimes they'll say this is a legal matter, hand it over to the law department, and then the lawyers rarely sign these. The lawyers just give the blessing.
Got it. Thanks.
You got it. Let it rip. Next question if you got more, guys.
No one's got one right off the bat. I can jump in, but I want to keep it open to our students first. Anybody got one before I jump in here? All right, Ferd, I got one for you. So we just closed on this park in New York State. New York State, traditionally a pretty difficult state to operate in. Specifically, you can't really raise rents past 6%. What we're running to now is we want to build back some of these expenses, from landscaping to water or submeter, et cetera. I'm trying to understand, if you, this is potentially state specific, so you can be as general as you want. Maybe you've seen it in other states, but we were told by seller that if we were going to submeter, that we'd have to reduce our basis of our existing rent, which you can only raise by up to 6% a year, by the amount that we're billing back. That doesn't necessarily make sense to me, because that amount, especially if you submeter, should fluctuate month to month. So how would you even determine what basis to reduce the current rents by? So I guess, do you have any experience there, and what would you recommend?
I don't have experience in the rent control states like that, but I mean, in general, I mean, I've seen things. Here's probably a similar example, and I've had people do this, they shouldn't. Like, let's say, I'm in Missouri. Missouri requires 60 days notice to raise rent. Let's say I want to raise the rent $30. I have to give at least 60 days notice. Well, what some people do is they go, hey, I'm raising the rent $30, but then 2 months later, like, man, my water bill and my trash bill is killing me. I'm gonna just put the water bill and the trash bill on the rent on the tenant's ledger next month. Can I do that? And I'm like, well, if you lived there, would you consider a $30 rent increase to be a rent increase? And the answer is, of course, yes. If you lived there and you were previously paying $0 in trash, and now you're paying $10 in trash, would you consider that to be a $10 rent increase? I think the answer is yes, because there's a cost increase. So if you're passing costs down, I think the best, in order to not have them be invalidated later, I would recommend, and I do this, I'm passing trash down, I'm going to give a 60-day notice as if it was a rent increase. So with that logic in mind, I mean, the devil's in the details. You got to read the statute or talk to the Public Service Commission, whoever regulates this in New York. But it would be my assumption that if the rent is currently $100 and you want to go up as high as you can, and the state limit is 6, then you're going to have the option to go up to 106. But if you instead say, I want to go up $5 and pass through an estimate based on, historical averages of $2 of water, I would imagine that they're going to say, nice try, buddy, but that's 5 plus 2, which is 7, which is greater than 6% on 100. Now, there might, the rent control laws are very well, if they're written well, which they probably are, they're going to be very specific. So I don't know, and even in city specific, but it could be the possibility. So I just, as a kind of a conservative approach, whenever I pass through costs, I treat them like a rent increase, and I send out the statutory notice. If there's a cap, I would call your state MA. I mean, I can look at it for you want, but I mean, it'd probably be faster, cheaper, easier to call the New York State Association. That guy or gal that runs that place should know that question and answer it off the back of their head. And that's what I'd, and then, and or just figure out which government agency it is. It's probably only a, um, 30-minute research project.
Yeah, that's interesting because it effectively would mean that I have to cap how much water I can charge back every year, and that has to increase by no more than 6% annually.
Yeah,
Which is just interesting.
I haven't looked in, Jeff Cook is a guy that owns like 6,000 sites in New York State. He'd probably know the answer if you ask him. I don't have his cell phone number handy.
Giancarlo, you know Jeff, right? Are you on Giancarlo?
Yeah, he's an awesome guy. He's really a good dude. So yeah, I could ask him if you want to have his cell phone.
Yeah, sure. We'll connect offline. Thanks,
Yeah,
Giancarlo.
absolutely.
And thank you for tuning in. Do you have a follow-up question?
Yeah, I do. Well, no, not a follow-up, a different question if we're ready to switch gears.
I'm ready.
Yeah, go ahead.
All right. How's it going, Ferd? How are you?
Yeah, doing well, thanks.
Hey, I'm Tiernan. Me and Mike closed on this park in New York State, Western New York, and we were meeting some handymen today, and we're trying to get quotes on demo, cleanouts, all sorts of work for the vacant park-owned homes that we have. And one of these handymen actually offered to not demo, but take away this home that we need to demo. The town has classified it as uninhabitable. So we have no choice but to demo it. And he said he would just take it away with his truck. And I explained to him how that's absolutely not legal. It's a 1955, probably an 8 by 35, super old home, pre-HUD home. And there's no way that would be roadworthy. And, I determined that it's not roadworthy. It's not legal. But he was super gung-ho. Oh, I don't care. I'll just take it to my property. Nobody will know. I'm wondering, what is the legal implications if we did allow him to do that, which we know is illegal? Would we be held liable if, the thing flipped over down the road or the tire flew off and hit somebody, or is that on him at that point?
Well, I mean, here's the deal. If, the answer to every legal question is the same, and unfortunately, you're not going to like the answer. The answer is it depends. So if the guy pulls it away and he runs over the paper boy right before he leaves your park, who's going to get sued? The answer is you and him. If he runs over the paper boy 20 minutes away in his neighborhood, who's going to get sued? Probably just him, maybe you, but you're probably the hook. So the legal answer is, you'd have to, there's probably always some risk. You probably have to look at it. Practically, if it was me, and I've had this, I actually had a 1956 Spartan, same thing. Guy wanted to pull it out. I didn't want to save it. And he said, and it was small enough. He goes, I can hook it up to my Suburban. And I just said, okay, here's the deal. You're going to do it on Saturday, and I'm not going to give you permission in writing. And I need to see a copy of your insurance ahead of time, listing me as an additional insured. And if you get pulled over by the cops, I'm going to say you stole it. But go ahead, man, get it out of here. Save me $3,000. You get this thing. And that's what he did. And it worked just fine. He took it like he was a motorcycle chop shop guy, custom motorcycles, and he took this metal. It looked like an Airstream, and he took it back to his shop and he turned it into, a cool little clubhouse to show off in front of his motorcycles. So it made it 200 miles, no problem. I mean, if you think about the old ones, though, here's one thing, it's pre-HUD. So pre-HUD mobile home is illegal to transport if it's pre-1976. But think about those 1950s models. Those weren't manufactured homes in the sense that we know. How many times does the average mobile home move? Once, from the factory to the park or to the farm. But how about those metal ones? those were meant to be taken from town to town, pulled behind your F-150, kind of like an RV. So despite being old, it's very possible it is more roadworthy than any of the homes in your park.
I think it may be, and he was super on that same train of thought. He
If
did
it's
some
gonna save me
research.
3 or 4 grand, I would roll the dice, personally.
Yeah, I'm thinking the
That's
same
not the
thing.
lawyer answer, but that's
I,
just save 4 grand and um, get him to indemnify you. He's probably got insurance. You got general liability insurance. I probably
Yep.
wouldn't, yeah, I'd probably do it.
yeah. How do you like additionally insured? You meant like on his just auto insurance?
Well, I mean, if the guy's just auto, then you're not gonna he's not gonna have that ability. But oftentimes, like I had a guy pull one out one time that was like an excavation guy, and he was gonna, you know, eh, well, he was gonna pull away to demo it, but his deal was I had to pay him, and it wasn't roadworthy in my opinion. But he was like, look, I can demo it on site. It's gonna cost you 5 grand, or I can take it to the dump and it's 3 grand. And I was like, okay, 3 grand sounds better. He goes, actually, to be honest, I'm not taking it to the dump. I got a field in the country with a big ravine, and I just take it out in the country and I burn it up. And it saves me the $1,500 dump fee. I'm still gonna charge you 3,000, but still if you go do it, I got 1,500 for my labor. And but he was an excavator for his day job, so he had regular insurance for that. So I said, give me a copy of that insurance with $1 million coverage.
Yeah, he has $1 million policy for his like construction insurance. He's a
Yeah,
roofer.
then you're in good shape. Then I would just have him list you as an additional insured, and it's free for him to do that. He just got to contact his insurance agent. And even if he doesn't list you as insured, he has insurance, but I would want to make sure that it specifically covers me. So
Okay.
I would
Yeah.
have,
So the main thing we need to worry about is getting it out of the park. Once it's out of the park, we don't have too much to worry. But I mean, he could pull it 10 feet into the road and then the tire blows or the axle cracks in half. And he's like, you know what? And never mind. He dips out of there. And then we have our home in the road. We
well,
can't
then
hire.
you call the police and you say some guy just stole my mobile home. He dropped it 10 feet in front of the park.
We might have to, yeah. Well, hopefully we'll avoid that. But I think that makes sense. I mean, it's worth it instead of
I mean,
the other quote we got was for 2 grand to
and
demo. So
if you're gonna, I mean, if you're gonna do that, and you're worried about it hurting something in the park, then just walk it out yourself. I mean, I used to walk the homes in myself because then they're not going to drive any faster than I'm walking because I'm right in front of them. And then they didn't go too fast around the corners and hit my electrical poles and my telecom and my picket fence. Said, hey guys, follow me. I'll walk you to the lot.
mm. Well, the good thing about it is it's right in the front, and
Okay. I mean,
yeah,
that's not really a legal, the legal question is I don't, you could get in trouble, but it doesn't feel like a high risk to me.
Yeah, it's about 50 feet from the beginning of the park to the home. So we'll just pray for that 50 feet and then it'll be fine after that. So appreciate the
Yeah,
response there from
tires popping and axles happen. That happens anyway. I mean, so I wouldn't, yeah, calculate a risk. It's not risk free.
yeah, I hear you.
When I was in business school, the guy talked about, this is kind of crazy, but my teacher said the first day of school, he said, raise your hand if you think it is okay for your customers to die from your product so long as you make money. And like nobody raised their hand. And he said, by the end of the year, all you guys are going to raise your hand. I'm like, what are you talking about, dude? And he said, here's the deal. You drive a Ford Fiesta. Do you think if you got in a wreck with a semi truck, you're going to survive? No. But you made money selling that Ford Fiesta, right? Right. Tell you what you could do from now on, you could, armor plate every Ford Fiesta and put it inside the shell of a tank. Now it's safe and it can run into that truck and not have any risk of death. Now it's going to cost you $2 million extra per Ford Fiesta, and you're not going to make any money, but that's your business model. He's like, no, you're not going to do that. You're going to accept that there's some level of safety risk, but it's mitigated based on the anticipated probability of profit relative to risk. So you're going to sell a regular Ford Fiesta. It's the same sort of thing here. Is there some risk that this guy's going to hit the gas line and blow up half the neighborhood? I guess, but very low. So your probability, of saving $5,000 is like 99%. Probability of losing $1 million is like way less than 1%.
Agreed. I love that.
But Doug in my office, Doug's a poker player. He played professional poker for 10 years before he got a real job. And so he's real good at probability. So here's what he talks about. Like, look, this contract provision says X. If it's only a 5% chance that X is going to be relevant for your transaction. But if we agree to X and it is relevant, that 5% chance, you're going to lose $1 million. Are you okay with provision X? And be like, of course not. I can't afford to lose $1 million. Okay, fine. We'll redline that one out. We don't want to be deal killers. We want to be deal makers, but gotta be okay. Well, we'll redline that one out. This next provision, it's got about a 30% chance of being a problem. But if it's a problem, it's going to cost you like $2,000 paying. And if we redline this, you're going to be seen as a really obstinate buyer and you may lose the deal. And they're going to go with the other guy and sign that contract. And by the way, your underwriting says this deal is going to make you $1 million. Are you willing to risk 2,000 times 30%? Which is a known loss probability wise of $600. You're willing to lose $600 in order to have the better opportunity of getting access to the 1 million. He goes, yeah, I will. So it's probability, and that's risk mitigation, cost benefit analysis in a nutshell. And then one other example from Doug, again, poker guy. He says, if I had a glass, I got a jar right here on my desk, and the independent judge tells you there's 50 black marbles and 51 black marbles and 49 white marbles. If I say, hey, Michael, do you want to pull a marble? You get to bet $100 on it. There's factually 51 out of 100 in here that are black. Will you bet $100 that you'll guess the right color? And what's Michael going to say? He's probably going to say, you want to play, Michael? You're going to say, deal. And you're going to give me $100 as a wager. You're going to guess black, because that's what the probability says. And then what are you going to do? You're going to pull a marble out. If you win, which you're supposed to, you get $100. If you lose, you lost $100, but bad luck. Okay, we're going to play again. One more time. 51 and 49. Okay, Michael, round 2. For this one, if you win, you get $100. If you lose, I get to shoot you in the head. Go ahead. You want to play? Chance to win $100. It's the same odds. We just changed the stakes. All of a sudden, Michael's going to be a little more conservative, despite the same underlying probability, because the stakes have changed. So that's how I look at everything. Does this market make sense with, lots of infill or low rents or private utilities or hair on the deal, or this contract is a realtor contract? Those suck. This other side is difficult as heck. The city's difficult as heck. It's just a combination of, probabilities and stakes, and then determining which ones you should proceed with and which ones you should walk away from.
I love that. Thank you for that, Ferd. I think I want to give you 5 minutes at the end to let everyone know how they can contact you afterwards if they want to engage you. But Shane, you got your hand up. Let's pass the mic to you so you can ask your question, and then we'll close afterwards.
Well, this is Jen.
Hi, Jen.
Hey guys, I'm in
Hey.
the car with Shane. So we are new. We're signing our first 2 parks. And we're wondering what the top 3 gotcha items are. Legal gotchas.
Got it. So there's a bunch. Earlier in the call, I think Michael's recording this. So for everybody else, I'll let you say,
Oh, okay.
go listen to the long analysis on zoning letters. So zoning is a big one to make sure you're able to operate the way you think you're going to operate, which would include generally operating permits, and then depends on the business. So zoning is a big one. Proper title and survey is a kind of a big one, but it doesn't. That's like low probability of problems. But it's like that example I gave a minute ago of low probability of pain, but high pain if you lose. So, for example, you think you're buying the property from John Smith, but if you don't look at title, does John Smith actually own it, or is there like $1 million lien on it? Or does John Smith not own it and it's owned by Susie and Bob Smith, his parents, but there's a probate dispute between John and his 10 siblings, and now you're gonna be locked up in court. So title survey is a big one. Zoning's a big one. I mean, the other gotcha really, it's not really legal, but I mean, as an operator too, I mean, here's I tell people, if you do your business plan, the financials, you're gonna put something together in Microsoft Excel. There's a 0% chance your business model in Microsoft Excel ends in bankruptcy. Every single deal, you got certain assumptions and implementation that you're making that you ends with some sort of profit percentage or return metric, and one that you ultimately say, yes, I'm going to move forward on. So there's no bankruptcy in Excel. But what happens in real life? There's bankruptcies every single day. So why is that? It's because people have a rosy view of how they're going to be able to implement the business plan. For example, if it's your first deal and your current experience level is, I just graduated high school yesterday. I've never had a job in my life. I have no money. I have no construction skills. I have no sales skills. Okay, that's probably not you, but if that was you, you might be able to run a decent mobile home park. But if the park is 100 units with private water, private sewer, lots of CapEx, rough and tumble tenant base, and it's 90% vacant, and the 10% are 1970 trailers, and it's in a town of 500 people, and your business plan says you're going to fill that puppy up from 10 to 100 in the next 5 years, on Microsoft Excel, you're going to make $10 million. But in real life, I think you're going to have a really hard time pulling that off. So to me, it's really just, the gotcha is I see a lot. I mean, I have one client in particular. I remember he's lost his shirt, and he lost his partner and split up, and then they were separated. Now they're both losing their shirt, and they still send us legal work because they're trying to save other deals. They're chasing the next deal for some reason. But he told me his first deal, he goes, here's what we're going to do, Ferd. We're going to buy it with this hard money loan, and then we're going to fill it up. We're going to fix it up. We're going to increase the rents, and in 6 months, and we're borrowing the money for down payment from this guy. We're borrowing the money from the seller on this guy. In 6 months, we're going to do a cash out refinance. We're going to put $1 million in our pocket, and then we're going to be good forever. And I said, what's your net worth? Well, I got a little student loan money, school didn't work out. I got a negative net worth, but I'm a hustler. I said, what's your experience level? Well, nothing. And I said, but you're going to get a bank to give you, which bank is going to give you a cash out refinance on somebody with no net worth, 6 months of seasoning? That's if you pull this off. I'm assuming you pull off your business plan. How are you getting the bank to take you out? And he said, we'll just find a bank. I said, I got a lot more experience, a lot more liquidity, a lot more net worth, and I can't get that loan. I don't think you can get that loan. But your business plan assumes you're going to get that loan. In the meantime, you're going to take a loan shark loan that's going to choke you if you don't get it over the hump. And he said, just do the paperwork. I'll handle the business plan. So we just shut up and we did the paperwork like a basic lawyer. One of us was right. So it was me. So the gotcha is not questioning your own assumptions and being unrealistic. So from a legal standpoint, that could be things as simple as, yeah, I don't need leases. The last guy told me I don't need leases. Or, I don't need to follow the eviction procedures. I'll just turn off the power if the person doesn't pay rent. That's called a self-help eviction. You're going to get sued. The business plan is, I don't need to ask the city's permission to turn on the electricity. My dad's an electrician. He's just going to hook it up. It works until it doesn't. So it's the big DD items are, just rattle them off real quick. Market test. Is there enough people there? City permits, state permits, phase 1 environmental, title review, survey review, zoning letter. Is it bankable? Which on a lot of seller finance deals, the only bank that's looking at it is the seller. He's going to approve you and take your down payment. So is it bankable? And then, look at the size of the lots. Can you, if you have an infill plan and you got 40-foot lots, is it realistic you're going to find enough 40-foot trailers?
Thank you, Ferd. And I think we'll take you up on those top 10 diligence items on one of your next calls. And for everyone listening in, Ferd, depending on his availability, will be here every other month or every month, again, depending on his availability for an hour-long Q&A. And we really appreciate it, Ferd. This was really enlightening. I think we got a lot of questions answered and covered a lot of ground. So on behalf of everyone here, thank you. And, we have additional people watching on the live stream. Thanks for joining. Ferd, I'll hand it over to you to kind of have any closing thoughts here.
Yeah, no problem. Thanks. You guys want to, shoot more questions my way, happy to do them or give them to Michael in between sessions. I can address them next time. I've got a podcast with got tons of free information. Just check out the Mobile Home Park Lawyer podcast, and then that'll address a lot of topics. some operational, some underwriting, case studies, legal, any of the above. You can just Google me, Mobile Home Park Lawyer. There's not that many of us. So if you find that, you'll find my website or find my podcast. You can shoot me a message on there. But yeah, glad nice to chat with you guys. And till next time, thanks and God
Thanks
bless.
so much, Ferd. Appreciate it. This recording will be available, guys, within the school community. Just go to the classroom and then click on Ferd's face, beautiful face, and you'll see it. So
Ferd.
you'll see the next one posted there as well. So make sure you sign up. Go ahead, Eric.
But I was just saying thanks, Ferd. Appreciate the time, man.
Yeah, you got it. All right,
Thanks so
guys.
much, guys. See you next time.
Bye now.